I tell clients all the time is it's fine to be mad. It's fine to be upset that people do bad things. I'm upset about it every day. Nobody calls me unless there's a dumpster fire, and I'd make the mistake of internalizing other people's dumpster fires. I'm upset all the time. But what you shouldn't do is let your money be mad with you.
There's an entire generation of Americans who no longer care about prestige, titles, work travel, fancy offices, and lunches. Welcome to Mundane Millionaires, a podcast for this generation of small business owners who want to set their ego aside and focus on what matters: family, community, quality of life, and cash flows. In each episode, Eric Pacifici and Kevin Henderson uncover what it takes to get a little money in the bank, control your time, and invest in building great families and lives. Let's get started.
All right, we're back again. Super excited to have Greg Brassfield with us. It feels like the setup of a joke. What happens when you get three lawyers on a podcast? But Greg
change
is
the station. Kevin, lead with that.
Everyone just tuned out. Our lowest listened to episode yet. Greg is a very accomplished litigator, and we wanted to have you on, Greg, to talk and kind of dive deep on discussions of maybe some strategy, or, how to think about what can go wrong in entrepreneurship. A lot of talk, especially in SMB Twitter, where Eric and I participate a lot, and places like that lately, about, being open and confronting openly and honestly the difficulties of entrepreneurship. Not everything goes well. A lot of times, maybe not a lot of times, but, frequently things will go wrong, go awry in these transactions, whether it's with the transaction itself, whether it's with the business once you own it post-closing. And I think that's some fair criticism. And I think an open discussion and dialogue is warranted over some of those things. So wanted to have you on to talk through some of those things. But before we get there, let's maybe set a baseline and just, walk through who you are, what your background is as a commercial litigator. And, so let's start there. I'll turn it over to you. Why don't you give us the 30,000 foot elevator pitch when you're introducing what you do for a living to people?
Not an advertisement or solicitation, though, for the record. Go ahead, Greg.
I got you. So, like I said, I'm Greg Brassfield. I'm a partner with the boutique commercial litigation firm in Dallas called Lynn Pinker Hurst Schwegmann. We're about 50 lawyers, and the way we sort of think about ourselves, and the way I think about myself, is we're a fairly small law firm, but we're actually a very large department because we've got 50 lawyers all kind of doing the same thing. We don't do immigrant law. We do some family law, mostly it's high net worth folks who make decisions that lead their first wives to get angry with them. So we do some family law stuff. Our clients are always innocent and in the right, of course. But like white collar investigations, all that kind of stuff that y'all have in your backgrounds, we don't touch any of it except for the commercial litigation portion. And as far as an elevator pitch goes, I got one. It's I'm the kind of lawyer everybody makes the butt of their jokes until you need me, and then you like me.
You've got the right name for it too. How often do people? And is that your legal God-given name, or you? I mean, that's too perfect, right? How often do people hire you just for your name?
Greg Brassfield.
I mean, bring in the brass, right? I can see this is like a Lewis Litt.
It's got like a Texas hammer, ring.
It does.
Yeah. I don't know how often people do that. Maybe that, and I should look into. I do have in my file of, what I'm going to be when I grow up. If I ever decide to be a plaintiff's lawyer, I've decided I got the perfect billboard name. And
yes, you do.
It's the Ginger Snap, because can get you money like that.
Yes, the Ginger Snap. He'll get you money like that, dude. That's
asterisk,
great.
not a guarantee. Past performance does not.
Somebody is going to steal that for sure. If anybody's listening to this, they're going to steal that because that's amazing.
For that common law trademarked right
You'll
here on
have
this
to
show.
like, either, you know, the little toggle thing when it asks you like how you heard or how you chose to do business. You'll have to have one for like based on name selection alone because that's strong. So
Yeah, that would be, I got a whole list of them. If some that's my best one, but if someone takes it, more power to you. I'll beat you in court anyway. So
yeah. Well, Greg, I'm super excited to talk to you because we run into this all the time, and we're seeing it more and more, like Kevin had suggested, with these sellers. Most of our clients are buy side small business buyers, and oftentimes we run into post closing difficulties, and that's when you come into play, right? And we'll get all kinds of questions about how do I enforce indemnity, you know, deal protections, non competes, the like. And you know, honestly, Kevin and I don't really know. We're not there trying to enforce indemnities. We have some visibility, but you know, we call you when we have issues. So I'm excited to hear directly from you. Do you guys think we should run through like just a series of issues and talk about how they're addressed, or how do you think we should go?
that sounds like a law school exam.
Let's
Let's do it.
let's do it. Let's test Greg. Let's see if we can stump him right here live.
Yeah, let's start with probably the most prominent post-closing issue. I've just bought a business. I've just given somebody, you know, a couple $1,000,000. They now have that several $1,000,000 and they turn around and they use that money to compete against me. We've had a couple of examples of that in recent times, and it's a difficult issue to solve, right? It's not as simple as just running to court and getting an injunction, I think, particularly when you've got people who are unscrupulous actors. So, from your perspective, Greg, what is the best way to one, prevent a competitive situation, and two, to address it when it happens after closing?
It's a good question, and I hope I can do this succinctly because it's complicated and, you know, very lawyerly answer. The factual circumstances dictate the answer frequently, but the first is I think there's a mindset that you have to go into these deals with, and honestly, whether you're doing a small business transaction, a mid cap transaction, or a large transaction, these issues are largely similar. So the same things that I don't think they're germane just to small businesses, but the answer is the first thing I want to talk about is your mindset. When you're going in and you're buying a small business or any size business, and the non-compete, the restrictive covenant of a non-compete, non-solicitation, that those things are important to you, you have to know people do bad things. It's why I have a job. It's why I'm hopefully one day going to be able to afford to send my kids to college, is because people do bad and stupid things all the time. You have to understand that is a possibility. And the mindset has to be a business mindset. You've got to say, at what point is this violation of the non-compete an annoyance versus at what point does it become an existential issue that I don't have a choice? Where it's an annoyance, in my view, the mindset has to be the solution isn't to run to court. The solution is to run faster in your business. And I'll give you an example of before I became a lawyer. I worked at a startup company out of Utah that subsequently sold for $8 billion. And the founder now owns a NBA team, you know, so, but in the early days when we were working out of the founder's basement in Provo, Utah, we were being very successful. And we had all kinds of people just ripping off the things that we did left. I mean, shamelessly ripping them off. And we would get all up in arms about, these guys are, you know, they've got all the resources in the world. They're private equity backed. They're just piggybacking off of us. They're coasting in our way, whatever metaphor you want. And the founder of the company, the true founder of the company, just had a mindset of we could run to court, we could blow a bunch of money, or we could invest that money in our company and we can just outpace them. We can out innovate them. And that's what he did. And that's why he owns an NBA team now. And all those guys ripping off the company don't. So I think that's the first thing you have to consider in this is what is the mindset. Now, when you switch from this is an annoyance, this is I'm not getting the value for what I paid for, and all that sucks. It sucks a lot. But when that turns into an existential issue, if I don't cut this off, then my business isn't going to exist tomorrow. No
Yeah.
amount of patience I have, no amount of creativity, no amount of hustle is going to overcome this problem. And you got to call someone like me. Then you are in injunction land. You are in this immediate relief land. And we can talk about that, but let me just pause there and make sure y'all get a chance to weigh in up from your perspective on whether what I'm saying makes any sense.
I think it makes sense intuitively. I think the pushback that we've heard, and I think there's something to be said for that. And I don't know that there's a good answer other than, how you let off. There are just bad people that do bad things, unfortunately, and you can't always control it. And that is it, it, it's frustrating, I think, to a lot of searchers to have put all this time and effort, to have candidly paid for high quality advisors, et cetera, to do a good job, to negotiate a good agreement, et cetera. And then here, yeah, you just got to run faster. There's not a whole lot you can really do about this. I don't know that there's a good answer for that. So I want to talk for a second, maybe about the second piece where you really are having that existential issue. And how do you think through, how do you counsel clients when they call you in that position and say, the predicament I'm in, like I'm having this existential issue, and the predicament I'm in is this is harming my business so badly that I am like on the ropes from a cash flow perspective. And my counterparty that's competing with me is sitting on a pile of 3, 4, $8 million cash that I just gave them. Like even that feels like a losing proposition because you're just going to get outspent. Or am I thinking about this incorrectly? Like, how do you work through that with a client?
You're absolutely highlighting the key issues. The only thing I'd push back on a little bit is there's always something you can do, right? It's never the case that you can't run to court. The question is, does that make sense financially? Does it make sense from a prudence standpoint? And
Sure.
those numbers, and I'll get into this as part of your follow-up question about, how you balance the cost, because that's part of what we talk about.
Right.
But principle I tell clients all the time is it's fine to be mad. It's fine to be upset that people do bad things. I'm upset about it every day. Nobody calls me unless there's a dumpster fire and I make the mistake of internalizing other people's dumpster fires. I'm upset all the time. But what you shouldn't do is let your money be mad with you.
Yeah.
And so there's always something you can do. You're just deciding to let your money be mad alongside you or not.
Well, Greg, let's be really, concrete about this so that the audience understands and can weigh. Like, talk practically. I believe it's an existential crisis and I need to stop them. What does that look like in practice? How much does it cost? How long does it take? How difficult is the process to go to court and get them to actually enjoin the counterparty and force them to stop? And then is that even enforceable? The court says stop. How do you actually in practice make them stop?
Great question. And let me answer it with an example I have seen dozens of times, that I've dealt with dozens, scores of times, including last week. An example would be where we've got a company, it's a small company, it's up and running. They've got some insiders who were hanging on after the sale of the company to help transition the business. We found out that they were using that time. I don't call them the defendants. I always call them the bad guys because I have to wear the white hat, right? So the guys were using the time, not helping transition the business, but using their email accounts, contacts, resources to create a directly competing company and stealing business opportunities, right? Right out from under the nose of the folks who had bought the business and really were making it successful. And we found out, And we had to do several things. The first thing that we had to do is use the existing governing documents, the organizational documents, to remove these people because they actually retained a board seat, and remove them and get them out. We did that the same day. We filed within 2 days of finding out this happened. We had removed them. We had to hold a meeting, have a vote, go through all the procedures, remove these people from their board seats. We had to terminate them on that same day. The next day, we were down at the courthouse with a lawsuit and a request for a temporary restraining order. This is what we call injunctive relief. Injunctive relief means stop doing something you're doing now. And there's two flavors of it. One is the thing that's immediate, right this second. In Texas, we call it a temporary restraining order. And that only lasts for a short period, like 10 days. And then you've got to get a temporary injunction. And that says, stop doing the thing you're doing until we resolve this in the lawsuit. And you got to win both. So in this case, in response to your question, we had to do a lot of things. It had to be done within 48 hours.
Yeah.
We ran down to the courthouse. We slapped the petition, the temporary restraining order request on the court's desk. We held about a 3-hour hearing, and the court said, yeah, I'm looking at these emails. I'm looking at the contractual agreements. I'm looking at the restrictive covenants. I'm looking at the non-competes that you have in place. I'm looking about the provision of confidential information, and all this stuff falls squarely in it. I'm signing this. So we had that done in 48 hours. The next day, we had to figure out a way to get that order in the hands of everybody and prove that we had served it, that they were aware of it. And now we are ankles deep into discovery. We're taking depositions in California. We're taking depositions of the businesses that were collaborating with these guys. I mean, that's the reality. That is extraordinarily time intensive.
Yeah.
I don't do much of this anymore myself. I have done it for many, many years, but I had associates work until 2, 3 in the morning to get these requests and these motions and these petitions letter perfect. Because when you're seeking an injunction, when you're asking a court, make the other side stop doing this right this very second, even though they haven't had a chance to really refute what I'm saying, you've got to meet a bunch of high bars. It's what we call extraordinary relief. It's not the common everyday quotidian relief you get in court. It is extraordinary. So your work must be extraordinarily precise. Your evidence must be extraordinarily good and put together. Your affidavits and your declarations and all the stuff you swear under oath has to be extraordinarily perfect. And then and only then can you get a court to say, time out, stop doing everything. And the reality, not only is it time intensive, it can be done. It's always a great expense. And I never quote a client. It doesn't matter how big or small. I never quote a client less than about $40,000 to $50,000 from my firm to go out and get this done. And if I don't think you have a very good chance of getting the injunction, I will tell you, I'll do it. You want to pay me to do it, that's fine. But I don't recommend it because there's no guarantee I'll see it your way.
And I don't know if ethically you can say this, but what are the success rates? I mean, you go out there and you challenge these, you've got a clear cut case of competition. He's just sold me, or he's just sold his business, or she's just sold her business. Immediately turns around. You've got paper trails, emails. Is that a slam dunk, or do you sometimes still lose those?
Well, my success rate, I would say, is very, very good, but that's because I'm very self-selecting, right? I take the cases that I feel very, very confident are going to achieve the outcome that we want. The other part of that answer is just generally speaking, it really depends on the quality of the case you bring, and it depends on the jurisdiction you bring it.
Yeah.
So these in California. California is a tough place to get a court, to persuade a court not to allow somebody to work. It's just a tough place. In Texas, it is far easier. In fact, in my opinion, it's a little too easy. I think we have a culture of reflexively enforcing non-competes that just exist on the piece of paper without a lot of analysis about whether that should actually be enforced, about whether the party seeking to enforce the non-compete has really met their extraordinary burden to show you're competing in a prohibited geographical area, whether you're really competing within the subject matter area. That's more of a state court issue. The federal courts are a lot more scrutinizing about it. In fact, recently there was this really great case here in Dallas where two really high profile Dallas radio personalities had been sued by the station that they were affiliated with. They broke off to do their own podcast. The station came out, said, we want an injunction, and they lost. I think they probably would have won if they'd been in state court.
Interesting.
They went and they filed in federal court and they lost. So some of it depends on the jurisdiction, but if you've got a clear cut, right? You're saying clear cut, in my case, there's a packaging, I'll say a packaging company, and the packaging contacts, the methods, all that kind of stuff is clearly encompassed within the confidential information. There's a clear non-compete, absolutely transparent that these guys, the bad guys, were violating that. Very, very good chance you're going to get an injunction. Very good.
Okay. And how often, just to ask the logical follow-up there, you already know you have a bad actor. You already know they don't care about the covenant that they already agreed to and were paid for. What's the likelihood, or how often do you see actually getting that injunction and they still just don't care and they still just keep on violating now an injunction?
And what's the penalty for that?
I know yeah, great.
Yeah. So that's fairly rare because usually at the time you get the injunction, there's another lawyer involved. It's fairly uncommon that you continue to be someone pro se in these examples. And so somebody not complying with the injunction happens. Fairly rare. If I were forced to guess, less than 10% of the time. And it's because a lawyer is going to go to the client and say, you had better comply with this because of the potential for a penalty, which is a court sanction.
Okay.
And does that become criminal, or what?
It can. It absolutely can be. And again, that sort of depends on the jurisdiction. But Texas, for example, contempt can be in a civil litigation matter. There are both civil and criminal contempt penalties. Now, the criminal ones, it's an even higher bar to show.
Yeah, sure.
But go out and you flagrantly violate a court order, then the civil court has the power to toss your anatomical hind parts into jail. They can do it for up.
It's a very eloquent way of saying your hindquarters, I think. Is what
that's a quotable for sure.
Oh,
Greg's children are listening to this. They're in his office right now. So.
If I start detecting something that I think is absolute nonsense, I'll call it bovine fecal matter.
We're gonna have our editors cut all of this out just to be clear, Greg. But so enforceability, though, let's talk about that. The words that we write on the paper, because we run into this question all the time where people will go, a 5-year non-compete, you can't enforce a 5-year non-compete. And I've got to explain, well, no, there's a distinction between a business sale non-compete where you've invested millions of dollars, and in the absence of that, people won't invest millions of dollars and you won't have a business buy marketplace, and an employment non-compete. But you suggested that California has a much higher bar for enforcement of non-competes than Texas. And so give us some guidance, like the words on the paper, like what is ideal? And there's one provision that I always see, and I always wonder about it aloud, the acknowledgement provision where the seller acknowledges that the covenants are an essential element of the agreement and that any breach of that provision will result in irreparable harm. What does that do, Greg? So what should the words say? What does that part do? And final part, I'm giving you a three-part compound question because I want to become a better drafter here. Oftentimes they'll push back on the 5-year, they want the 3-year non-compete. And I always tell my clients 3-year non-compete is 2 years of rest and 1 year of preparation. That's just not enough. What do you see? And so what should the words ideally say? What do they mean? And how do we have really high quality non-competes for our clients? All right.
This is where we find out what Greg really thinks about corporate lawyers.
And this,
So
that
go,
is,
Greg.
yeah, for sure.
You and as with most things, the answer depends. I think I can give some good general guidance, but let me tell you first where it depends. Starting with your second point about this language, we acknowledge it's enforceable. Well, if your provision is void because of public policy, it doesn't matter what it says. There is no amount of drafting that you can make to make that enforceable. You and I can enter into a contract that says, hey, I acknowledge that this black tar heroin is of the highest quality. And then you sell me something that's not. I can't run off to court and it because we're not allowed to enter into a transaction that's on its face illegal. So,
And this is the California example where employment non-competes by virtue of civil code are not enforceable. So it doesn't matter
And
how
actually,
you
it's
dress it up on
criminal to even
paper.
ask for it now, right? It's a criminal penalty to ask for a non-compete.
in some cases, yeah. In some cases, it is illegal. It's contrary to public policy. Utah has followed this trend. There's a whole bunch of states that are looking at it right now. And they're just presumptively, at best in some of these jurisdictions, if they're not on their face unenforceable, then they are presumptively unenforceable. You just start with the assumption that you can't. And then if you're trying to enforce it, you've got to overcome.
You've got an uphill battle.
Yeah. But in Texas, we don't have that. And if you've got language that says, hey, I acknowledge that this is an essential part of the contract, you've got a pretty darn good chance of getting that enforced. You've got a pretty darn good chance of getting a temporary restraining order, a temporary injunction pending the outcome of the trial. You got a pretty good chance. So it depends on the.
And
Now,
just to put a finer point on that for the audience, employment non-competes are illegal, but business sale non-competes in California are not. Similar
Right.
to I think the FTC put out some suggested
Correct.
rules making all employment non-competes illegal, but I believe in that guidance they explicitly carved out business sale non-compete. So an important distinction.
yeah, that it's a critical distinction, and in business sale non-competes are not anywhere in the same ballpark as the employment non-competes in terms of the restrictions. I tend to agree, 5 years is pushing it. Again, this really depends on the jurisdiction. I see 5 years enforced all the time in Texas.
Yeah.
That's really hard to get in other places. Not unheard of, and there's sort of a sliding scale in really how specialized are you? If you're just somebody who flips burgers, it's pretty hard to enforce a 5-year non-compete because there isn't anything really specialized about that gig. So there's sort of a sliding scale, but I see 5 years enforced all the time
For business sales.
for business sales. I see employment non-competes in Texas enforced on a 5-year basis. So
Jeez.
I have my opinions about whether I think correct, whether that should be enforceable, but I'll reserve those. But it really depends on the jurisdiction. Interestingly, in Europe, and Kevin, I know you spent some time across the pond, there's what I think is an ideal situation, and it's referred to as garden leave.
Mm-hmm.
And it is, you can get a non-compete for as long as you are willing to continue paying for it. So you want me to sit out? I'm still on your payroll while I'm sitting out. And then it really sort of puts the proof to the company, like, is this actually valuable? Is this non-compete actually valuable to my company? Or is it just me trying to,
Be
you know,
punitive.
be a little bit punitive and keep itching out? And it's amazing how frequently someone says, "Hey, I'm going to continue to pay you for an estimated 3 years," and after a year they go, "No, I'm done with that. I don't think this non-compete's all that important." So that's an interesting thing. Now, the third part of your question was ideally how do you draft these things? And the answer is you've just got to track whatever statute applies in that state. Every state is going to have some sort of geographic restriction and some kind of subject matter restriction and probably some sort of temporal restriction. And so when you're drafting these agreements, you've got to make sure that you have identified where your primary market is and that you've hit whatever prongs exist in the business code to say it's within 100 miles, it's no more than 3 years, and narrowly tailor or be as explicit as you possibly can in the terms of what the subject matter of where they can compete and where they can't compete is. Because I will tell you, every experience I have with a judge, the judge is always looking to give the person seeking to compete a break. Always. And they will construe non-specific clauses in favor of the person trying to go out and get a job.
Yeah.
So you need to be highly specific if you can.
Yeah, and just to give the audience an example, like Florida, three years or less is presumed valid. 7 years or more is presumed invalid in terms of duration. And then everything else, including the scope, needs to be reasonably related to legitimate business interests. So when you think about that, it's a little squishy, and I'm sure there's some case law to guide us. But if you're selling a car wash that only pulls customers from a very small geographical area, saying the whole state of Florida makes no sense. If you're talking about a national e-commerce business that sells, ice cream equipment across all 50 states, then the entirety of the US would be legitimate business interests. So it's kind of an interesting factual. What happens if we get it wrong, Greg? We say 6 years or 5 years even. And the court goes, no, 5 years is too long. Are they going to throw the whole thing out? Or are they going to say, how do they fix that?
Yeah, they do something that we refer to as blue penciling. And a court is not going to come in and say, "Hey, you picked 6 years instead of 5. You are 1 day over what was allowed. So now you get nothing." That's not what happens. What they'll do is they'll blue pencil and they'll go in and they'll say 6 years isn't enforceable. I find 5 years is enforceable. So now your contract is for 5 years. And, it's something to think about when drafting and when you're negotiating these things is, how diligent do you want to be making sure that what you are negotiating is really truly what you need? Because if you're trying to reach, if you're trying to stretch and see how much you can get away with, what you're doing is you're inviting in Texas, an elected government official to weigh on what they think is best for your business practices. And you can roll those dice. Nobody's ever happy when that happens. But that's the procedure. Is they'll come in, they'll look, they'll say, "Yeah, I'm looking at your definition of the scope of the non-compete, and I get the first 5 areas. I don't get the last two. So blue pencil, I'm just striking those out. So you get 5, you don't get the other 2.
Yeah, and I'll throw for anybody who is watching here, I'll put the Florida statute on the screen just as an example, and then I think we probably move on to a different point. But so Florida refers to, in the case of a asset of the business sale, share of a corporation, partnership interest, limited liability company. So effectively any business sale, as opposed to the employment situation, which we talked about previously. The employment situation is handled differently. They say 1 to 3 years is kind of the range there. Less than 1 year in duration is presumed reasonable, and greater than 3 years is presumed unreasonable. They then break out business sales separately, and they say less than 3 years in duration is presumed reasonable, and greater than 7 years is presumed unreasonable. So that's to your point about when you're drafting a non-compete, you look at the applicable state statute and make a decision.
Precisely.
Yeah. Yeah. I wonder, before we move off we've spent a lot of time on non-competes, but I think it's probably the biggest elephant in the room for a lot of entrepreneurs. So I don't think it's wasted time. I do think, we've been approaching this conversation a little bit like three lawyers, and it probably bears just pausing for a second and breaking down really quickly what we're talking about when we say a temporary restraining order, a temporary injunction, etc. And it's important for the audience to realize the way, and Greg, keep me honest here, but the way the court system is set up in the US from a civil perspective generally disfavors forcing people to do something or not do something. Generally, it's set up to award damages to one party or the other. And so before a court is going to say, hey, rather than saying you owe X amount to the other party, and instead say you actually have to stop doing something, which is a restraint on the freedom of that person to do something, that's where we get into that extraordinary relief. So I think some people may be confused. The reason we have a temporary restraining order is because you, as the plaintiff, are running into court without the counterparty, asking a court to say, slap a court order and tell them to stop doing what they're doing without them ever even really having any real form of due process to defend themselves. And so the court's going to say, man, I'm looking at this. This is really terrible. I'm going to give you the temporary restraining order, but it's going to be a very short period before you have to haul in the other party and let them defend themselves. That's where you move to the temporary injunction. The court will hear both parties and be able to say, okay, now I'm also hearing the other side. I'm still uncomfortable with what you're doing. So we're elevating this TRO, this restraining order, to an actual temporary injunction, which will be a slightly longer duration before we have a full blown out hearing for what would then be a permanent injunction. So I wanted to break that down for listeners really quickly. Correct me if I got anything wrong there before we move on.
That's largely correct. They're super disfavored, and great big neon flashing caveat here is, if your complaint is, if you allow the bad guys to continue to do what you're doing, it's going to cost me a lot of money. You will not get an injunction. Money damages.
Yep.
That's just regular run of the mill litigation. That is not extraordinary relief. All right. Oh, and I get a lot of pushback on that. It's just the reality. It's my go-to. Judge, all they're complaining about is it's going to cost them money. We can deal with this in the course of litigation. No reason to stop us. Second quick clarification is, an injunction by its nature is, don't do this thing. Don't cut down the tree. Don't euthanize the puppy. Don't do something.
Right.
Injunctions can require people to do things. That's even more rare. That's
a great clarification.
So you want to say, if you want to go from just stop doing the thing you're doing, stop communicating with people, don't cut down the tree, don't euthanize the puppy, versus euthanize the puppy.
You're killing me with the puppy analogy here, Greg. I'm trying to hold it together, but I'm a dog lover, man.
Well, before we run out of time,
let's
harping on non-competes. Right? What else do we got, Eric? What other issues come up?
Indemnity, right? That's always the biggest thing. So you buy a business, and the seller, for the audience's benefit, has provided you with a long list of reps about the business, representations about the current existence of the business. And they do that because diligencing a business to the extent to ferret out every imaginable skeleton, not possible, not practical. And so you don't do that. You don't even try. You just say, hey, I'm going to ask you to make a bunch of assertions about the nature of the business. I'm also going to ask you to do a bunch of covenants, like the non-compete, right? A covenant is an action you have to take or an action you cannot take. And to the extent that any of those statements, reps about the business, turn out to be untrue, so you breach them, or they're just wrong, or you don't do any of the things you're supposed to do, or do things you're not supposed to do, then we have a pre-baked contractual dispute resolution mechanism in your agreement. It's really the only thing that's going to save you after closing, in my opinion. No one's coming to rescue. Your QOV provider's not coming to rescue you. You're going to look at those words on that paper, and that's going to be the only thing that's going to probably save you in the deal. But then oftentimes in those provisions, you've got to go to court and you've got to prove up that there was a rep breach, or you've got to prove up that they were competing when they weren't supposed to be competing to get that indemnity relief. Talk to us practically, Greg, and I'll give you an example. Let's say the assets of the business, one of the most important reps in an asset deal is that the assets are sufficient for the business purposes and that they're in good working order, is oftentimes what the buyer will want. Seller will try to sell them as is, but you should push back if you're a buyer and say, no, I need these assets, contributed to the valuation and the profitability. I need them in good working order. Well, you show up on day one and there's a bunch of trucks that are not, in a good enough quality, or you buy a towing company and the trucks aren't in sufficient quality to operate. In fact, they're not even legal to drive on the road. And the employees who you just inherited go, oh yeah, no, the seller told us that you were going to fix all this when you showed up. How do you go about enforcing that indemnity relief in the most practical possible ways? Do you go make a fuss on day one? How hard is it to prove up those claims? And just talk to us about indemnity generally.
Yeah. So indemnity is a mechanism typically, indemnity is a mechanism whereby you recover your out of pocket expenditures for attorney's fees, costs that are incurred as a result of, somebody doing something they ought not to have done. But the way I view this is indemnity is an after issue. It's not a during issue. It's not a before. And here's what I mean by that. There's another concept called advancement. And advancement is usually reserved for directors and officers of the company that say they're ever accused of doing something wrong in their capacity as officers and directors of the company. The company will immediately on day one and throughout the pendency of whatever controversy they're experiencing, advance fees. So if someone like me goes in, I'm defending an officer or director of a company. I send them an invoice for December of 2023. The company cuts me a check. I'm advancing those expenses. Indemnity is after the fact. Indemnity is after you win on your position. So in your example of the trucks, I say you breached the reps and warranties regarding equipment in good working order. That's a breach of contract lawsuit, right? And I go to court. I say they breached the contract. I do discovery, go to trial, get my jury verdict. Jury says, absolutely, you breached the contract. What are my remedies? What is my relief? Well, among other things, I can invoke indemnity. I can say, now you owe me for everything. You owe me my fees. You owe me my costs. You owe me my expenses. You owe me whatever that is. So that's what I mean by that's an after the fact. A lot of people will read indemnity and say, you breached the rep, the warranty, you breached the contract. I'm out of pocket. Give that to me now. Well, you're only entitled to indemnity after you prove the predicate cause of action. So,
Well, and it depends on what the contract says, and if the contract requires that proof, and I think most market transactions do, but you're right.
and there's no reason that you couldn't attempt to negotiate for something that says, hey, if I bring it, X, Y, and Z actions, if I discover X, Y, and Z things, and I'm required, to take remedial measures up to and including litigation, then you have to indemnify me, which means I'm going to send you whatever costs I incur on a monthly basis. I don't know if anyone would agree to it, but there's no reason you couldn't try.
So what you're saying is, in advance of actually that judgment, you say the contract says, if I have a rep breach claim, you're going to pay me until we get a third party adjudicator to decide on it. And what happens if we have that language in there and then the ruling is adverse to the party seeking debt? They got to pay them back, or what's?
Depends on what the contract says. I will tell you in advancement situations, because that's what we're really talking about, where it's a bete noir of mine that people blend concepts of advancement and indemnification. So I'm willing to swim in that shallow end of the pool for the conversation, but the really you're talking about advancement. What typically happens there is the company says, I will give you all of this money, but you have to undertake an obligation that if it turns out you did breach your fiduciary duties, you were guilty of insider trading, all of the money that we paid you has to be paid back. That's pretty standard.
Yeah.
Now, the procedure to invoke all of this stuff is a little mushy everywhere except for Delaware. Delaware has awesome procedures. They have expedited procedures. The the presumption is that you're going to get your advancement, you're going to get your indemnity. They're very, very favorable. And a lot of the more sophisticated jurisdictions like New York, like Texas, like California kind of crib off of those procedures. And so even where jurisdictions don't have clear cut case law or statutes governing how the contract should be interpreted, a pretty good move is to say this is what they do in Delaware, so that's why you should do it, and they'll kind of default. But your question, how do you get it? You file your lawsuit for breach. You say, among other things, I'm entitled to indemnity, and if you prove your underlying case, you'll be indemnified.
Which raises all the similar types of questions that we confronted at the start of the conversation with non-competes of a calculus of cost, time, distraction, etc. The best case scenario is a reasonable buyer and a reasonable seller coming together, realizing there's an issue and agreeing to some form of indemnification. Yeah, that's a big problem. I don't actually think it's $80,000. It's really $45,000. You negotiate, you settle on what it is, and you agree on some indemnification. Otherwise, you're right to that square one of how much is this going to cost me to engage a litigation firm, to go down this rabbit hole, to file a lawsuit, to litigate this, to recover the $80,000 on this truck that wasn't working properly. And you're making that whole same calculus all over again. Am I better served paying the $80,000 to fix it and go all in on just running harder, faster, and improving my business?
It's
It could be a tough calculus to make.
It's 100% correctly, and unfortunately, in the small business and mid-sized business community, the reality is that the relief you're seeking and the expertise you need to competently and successfully prosecute some of these things, the amounts at issue don't really play into it. Just because you're saying, hey, this is
Yeah.
only a $200,000 issue and not a $200 million issue. I could say within 10% of costs, I could do a $200 million non-compete dispute. And it might only cost me 10 or 15% more than to do a
200,000.
The steps are all the same. So that's a reality. And people go, why is this so much? Why are you sending me, a $1.5 million estimated budget to litigate this to the end? It's only $300,000. Well, because the work that we've got to do is the same, regardless of how much you think it's going to cost you.
Yeah.
So, Greg, let me ask you. We run into two issues, and they're pretty similar issues with indemnity over and over again. Number one is sellers counsel want to remove the sellers from personally backstopping the indemnity. They also want to take away any backstop in the form of either a note set off or a escrow account. And escrow accounts are a little bit difficult in small business M&A because of SBA requirements. They don't really allow you to set aside cash. So oftentimes you got to use the note set off, and they'll try to strip that out. They'll try to take the sellers off the agreement, which puts you in a position where your recovery would be against a shell company. It's sold all of its assets, and now that's your counterparty to go seek indemnity against. Talk to us about, give us an intelligent explanation that I can share with my clients moving forward as to why that should be such a non-starter when you're agreeing to buy a business.
Well, because it just de-risks for the individual who has all the incentive to act poorly, and you can't let them do that. They've got to carry the risk of their bad acts with them, at least for some period of time. And what I sort of encourage people to do to get entree into a PG or something, a personal guarantee, or other types of guarantees is, offer them a burn off, after, you know, you're personally guaranteeing for $5 million. And then if you're playing nice and you're not in breach of any of your agreements after a year, then it goes down by $1 million every year for 5 years, and cover yourself that way. But you're 100% correct that it should be a non-starter, because if I'm an individual getting all the cash, getting all the upside of the company, and I am not on the hook for my bad acts, then what incentive do I have to make sure that I'm complying with every jot and tittle of the contract? I don't. I really don't. Go take the business, go take the piece of paper that the LLC is, go take the fictional entity. What do I care? They got to keep skin in the game to make sure they're staying honest. And not even honest. I don't want to suggest that people are out to defraud or out to screw you, but they need to be careful about their decisions on what they do. They need to make sure that they are being careful about complying with their obligations, and that when they have opportunities that pull their loyalties and pull their interests in competing directions, there needs to be a check to make sure that they're considering the consequences.
Yeah, I think it's a super important nuance, because at least from my seat, the instances of like defrauding buyers is pretty low. The more likely scenario is just something went wrong. There wasn't fraud. A lawsuit got served for something that happened a year before closing. The truck broke down because it wasn't maintained to specs or something like that. And it creates, like you said, that poor incentive of like, man, that really sucks, but I'm not on the hook here. So why am I going to offer up $100,000 to take care of this? 400,000. So it's not even fraud. Like you said, they got to have that skin in the game, to have that incentive to play ball, to negotiate, to figure out what to do and to make you whole. Otherwise, even good people are going to be like, well, I mean, if I don't have to, why would I? So yeah,
It incents them to really about their reps and warranties. It's easy to say, yeah, I drive these trucks all the time. They're fine. Right. But if I'm on the hook, if some of them break down 6 or 8 or 12 months after the deal closes, maybe I take them to a mechanic and just have them once over before I make the rep and warranty.
Right. And I always think about it and try to describe it as fixing the machine. You're buying a business that is a machine. It's made up of parts, contracts, physical assets, intangible assets, employees, goodwill, and you need all of those components, that machine, to produce an amount of cash flow. You're paying for that cash flow, and you're guessing because it did X amount of cash flow in the past that it'll probably, hopefully, do Y amount of cash flow in the future, and you pay for that. And so as the components of that machine are broken going forward because of, things that could have been remedied or the like, you need to have a fix to remedy those breaks so that you'll get the benefit of the cash flow that you were anticipating. And that's your mechanism. And if you're recovering, the seller sells all of their assets in an asset sale, and the only person that's on that contract now is that selling entity, and you've got a broken truck that wasn't in workman's-like condition, and you've got to go replace it, you're going to try to make that recovery against that shell entity. And guess what? It's got nothing in the coffers, no money, no nothing. It may not even exist anymore. They may have wound it down, and then you're out of luck. And I had to tell a seller's counsel yesterday that, taking the seller off of the agreement, couldn't understand why, well, we may as well have a one sentence agreement that says, I'm going to give you X amount of dollars for Y amount of shares if the seller's not on, because all these other words mean nothing. They're not enforceable against anybody. And so we run into that over and over again, Greg. Yeah. And it's frustrating, but yeah. Well, and I get it. I appreciate that, but yeah.
I was gonna say, we only have a few minutes left, and I'd be curious if we're okay with it pivoting a little bit to sort of the business of the law and things like that, because I think that highlights like what we found in our space and kind of quality of legal counsel and things like that. And we've talked over and over on these two kind of very broad but super important issues about how hard it can sometimes be to enforce due to cost and things like that. Like, can we talk for a minute on the litigation side? We're very open about how we're trying to change on the transaction side, kind of the approach to practice, get higher quality representation at more affordable rates to people in kind of our smaller segment, the Main Street, premium Main Street. What's happening on the litigation side, Greg? Is there anything going on? Like, are there thought leaders out there talking about, are you thinking about, like, how can we provide some of these remedies, get relief for people at a more cost effective way to make the legal system not so difficult when it comes down to finances?
I yes, there are, and I'll tell you what I find the biggest obstacle to all of it. But let me just highlight maybe a couple of things. One is technology is making things better. It's making things more efficient. I'm sure y'all have heard the phrase going around that is AI going to replace lawyers? No, but lawyers who know how to use AI will replace lawyers who don't.
Yeah, we talk about that all the time. Yeah.
I think that's very true. It's not quite there yet. It's not, in fact, AI is not, in my opinion, not all that helpful yet. It's interesting, but not all that helpful. But technology is one way that will bring costs down. Automation. Lawyers are notoriously bad at business practices, and so they should have forms. I've got on my desk, you can't see it, but I've got something called a Stream Deck. And a Stream Deck is for gamers. It's like, there's a bunch of little buttons on it that automate all these processes for, people who are on Twitch and things like that. I've programmed mine. So I just got a million different templates for different things. So if I'm sitting here late at night and I don't have a paralegal or an associate, I just hit a button and it pulls up a template so I don't have to recreate things from scratch. So, those are the types of things that I think thought leaders are thinking about, is how do we automate processes that can be automated?
Yeah.
Use technology. How can we more efficiently use data to determine when we can use blended rates and alternative fee things? There's a lot in there, but here's this is the realistic obstacle as someone who's very interested in that and is always looking to create value propositions for people. The challenge that I think our industry faces in litigation specifically is, if there was an easy solution to the question, there's no need to call. I get the calls when the questions aren't clear. The solutions are difficult, when the case law is not evolved, when the legislature hasn't dealt with it on a statutory basis, when the Constitution is vague or silent on the issue. And there's no amount of technology or, process that can fix the fact that sometimes you just have to dig really deep down and think very hard about very complicated, fact-intense problems. And that is why litigation continues to be very, very expensive. Because I pontificate about generalities all day long, and then you throw in one tiny little fact about one conversation you had for 2 minutes that one time, that one day. And I go, well, now all of my assumptions are out the window. So probably the biggest challenge to changing frameworks. But, my firm does an awful lot of contingency and hybrid arrangements on the plaintiff side because we like to share risk with the client. So I think that's probably my view on bringing the model down. I think it's a little harder for litigation because there's a little less.
Yeah, it's super interesting. Well, I think with that, Eric, any final questions for Greg before we wrap up?
No, I'm chuckling because I have this Lumina AI camera, and it's got a mind of its own, and it just completely took on a mind of its own and reframed the video here as we were speaking. So
speaking of
adventures, are you still using the Lumina
AI
Kevin?
tool? No, I actually use a app that integrates with my iPhone. Most people don't realize, like, the phone in your pocket's like the best camera you'll probably ever own in your lifetime. And I don't know why we use these like shitty $99 Logitech things on top of our monitors. But anyway.
Well, just in case, for the benefit of the AI, I for one welcome our new overlords.
Yes, for sure. No, I agree, Greg.
Trying to stay in the good graces.
I want to say they are doing a great job. Elon's doing a great job. Federal government's doing a great job. IRS doing a bang up job. I appreciate the 5 address. There we go. The camera's moving again. I appreciate the 5. They're listening.
Yeah.
The IRS, track his face.
That's it. Appreciate the
maybe-
5 address updates they sent me in the last 2 weeks. So, Greg, anything you want to pitch, man? Well, I mean, obviously you introduced yourself at the beginning, but anything you're working on you want to talk about before we conclude?
I'm fairly active on, because I'm old, so I'm fairly active on LinkedIn. I try and create a lot of content that is actually practical, that's actually useful. LinkedIn is a big platform for people to say what award they paid for recently, and
Those are all real, Greg. All of my awards.
of course they are. And so I think just if you're interested in trial court persuasion and little weird factoids that are actually useful in court, then I think I provide a pretty good LinkedIn service.
Yeah, I love it. I'm checking out your.
Which I just realized we've been friends for 6 or 7 years, and I'm not connected with you on LinkedIn. So
You tried
And it-
one.
you declined me.
Yeah.
You're like, oh, this guy. This is the
You
Twitter
shot,
guy.
you shot,
No way.
Kevin. That's it. Cannot be associated with this. Greg, amazing to meet you, man. Super helpful stuff. And in fact, I think at some point in the future, we probably would love to have a part 2 because I'm sure that this is going to drive a ton of questions and,
I have no doubt.
response. So awesome conversation. Thanks for making the time to do it.
But anytime, gents.
Thanks for listening to this episode of Mundane Millionaires. If you enjoyed what you heard in this episode, make sure to follow Mundane Millionaires wherever you listen to your favorite podcasts. See you next time.